I was going to respond. I just didn't know if I want to pay homage to the dean of the court. If Commissioner Raddick would like to say something, I'm just assuming the comments may be somewhat similar, and I would be happy to respond to both.
If you want to respond to him, go ahead.
Okay. I want to first walk through what the consent decree calls for. It calls for a remedy that is systemic, and it will make us cure some long-standing constitutional violations. It will create an enforceable, constitutional, and transparent pretrial detention program. It will promote government's compelling interests in court appearance and public safety. It will ensure public access to information and be transparent about it. It'll set forth the charges and investments required to ensure that the new policies and pretrial policies are implemented, and it will protect against going back to the way things used to be. And I know it's probably difficult sometimes for people to realize that it takes an effort to bring about change, but that's the reality of it. Some of the conversation today reminds me of how long I've lived. Having been born in April of 1954, I think Brown versus the board came down in May, just in time for me. But being older, by the time the Singleton court ruled to integrate the schools in Houston, Commissioner Garcia, I was in the 10th grade. And at Worthing High School, thanks to Judge Singleton, we had a grand total of 3 white kids in my high school. And it was a great experience for me to be in that environment, and also for them. But I also lived long enough to see the walls of apartheid come down in South Africa. And the amazing thing to me is that when the walls came down, when I'd go to South Africa, everybody would talk about how they were never really for it, and would make one ask the question, well, how did it last so long once change comes about? Some of this discussion today reminds me, Commissioner Cagle, when I was in law school. And I remember being at the University of Texas Law School in 1977. We had a record number of African Americans and Hispanics who were in that class. And when we got to what are considered the great civil rights cases, you remember this experience in constitutional law, Slaughterhouse case in particular, I saw some of my classmates who would just bow their heads, some in anger and some in disgust, wondering how such remarkably intelligent people could use such creative language and such cogent logic until you got to the end of the opinion. And you saw that they were justifying outright bigotry. That is the real challenge for us in public policy. Because, as I've told you many times, our words are powerful things. They can be used to persuade. They can be used to hurt. They can be used to preserve the status quo, or they can be used to change it. You made the comment, and the previous court members would say it all the time. No one should be in jail because they're broke. But there are thousands of people who are in jail because they're broke. And the court found thousands of constitutional violations where people were in jail because they were broke. And it's not just here, it's all around the country. You made reference to our dear friend, El Franco Lee. El Franco would take the same position on these issues that I'm taking, but he didn't have the votes. And I want to tell you, we can differ on it. We'll have to ask him when we get on the other side. I hope you get there before I do. But surely one day we will all get there. But look, Commissioner Garcia with Sheriff Garcia when I think Franco sent, did I send a letter or did he send out a letter saying you're going to get sued?
Yeah.
I mean, look at every angle I could find to try to nudge this system in Harris County on the state level. I tried. But, colleague, these entrenched systems are hard to change. For a while, this court didn't even want to apply for the MacArthur grant again. Oh, yes. That came up before the coordinating council while you and I sat here. An intern on my staff found out about MacArthur, and I called Franco, and he said, hey, don't do your ranting and raving. Tone it down, get somebody to write a letter, send it over here, and I'll pass it out. You were sitting in the room. Eventually, folks applied when it was their political advantage. Y'all had a big press conference. Pat yourselves on the back. You're going after MacArthur grant. MacArthur gave us a third of what they would have given us, this county, because they didn't believe we were really serious about making changes. You made some reference to separation of powers. That argument, to me, is akin to states' rights. I'm all for states' rights until the states do the wrong thing. And then I'm against it. I'm all for separating the powers until separating the powers violates the Constitution. If the founding fathers didn't mean it when they said equal protection under the law, they shouldn't have said it. And they darn should not have written it into the Constitution of the United States. You can't defend a system with the people on this side of the room have money, same profile, everybody in the room has the same profile. If you're on the left side, you get out. If you can post bail. If you're on the right side, you stay in. The due process provisions, the reason the old court jumped in to give people lawyers at the magistration hearings is because they were running an assembly line. It's documented. These folks from top and others went over there, made the recordings public. It was shameful. And everybody who was a part of it bears some responsibility, including me. 26 years being in Texas. But here's the difference. Some people will put blinders on. For this system to last this long, there were people in power who either didn't know that it was wrong or they just didn't care. And whichever shoe fits, put it on. You talk about victims. If we believe people are innocent until they're proven guilty, if we believe that, those people are victims as well. You talked about the cost. This court spent $9 million. It's hard to figure out the exact number. I voted against the legal fees until I got here. I think I voted for it the last 2 times. That tab might be well over $10 million. And I'm sure that the old court would have gone all the way to the United States Supreme Court. Money would not have been a factor. It's a well-reasoned decision that Judge Rosenthal wrote. So well-reasoned. Even that historic anti-civil rights Fifth Circuit would not shut it down. So look, I'll close on this. I said to you when we were here before the 2 new members of this court joined, even if I'd be penalized for it, hey, even if I was disliked and folks find other little old crafty ways to get at me, I won't be on the wrong side of history. And I hope you won't either. The reason we need a monitor, the reason this is 7 years, there are things in here that we could do that the old court should have done. The old judges could have adopted a rule to remedy a lot of this. And this court sat here in blind indifference. And I want a system in place so even if Lena Hidalgo and Adrian Garcia and Rodney Ellis are not here, whoever comes after us will have to put as much effort into trying to go back to the good old days as folks put into putting it there. So that's why at the appropriate time, Judge, I will be honored to make the motion to approve the same. Thank you.
Commissioner, let's see.